We have a quorum this morning. I will call to order Senate Special Investigative Committee. We have a full agenda this morning. We have first, we need to approve our minutes from the last minute, and then we have subpoenaed Fonnie Willis to testify. According to press reports, she is defying her subpoena and not appearing, but we will welcome her if she appears at some point during the meeting. We also will have a presentation by Mr. Stuart Morelli of Legislative Counsel's Office. If you look in your folder, you will note that there is a memo that Legislative Counsel prepared back in 2016 dealing with legislative investigation, administering oaths to witnesses and issuing subpoenas. So we are guided by their work and their legal advice. So I wanted Mr. Morelli to kind of educate the committee and the public on this process of an investigative committee, as well as our subpoena powers. Following that, Mr. David Cook, our former Secretary of the Senate, who's been very involved guiding this committee through the process, will give us some insights from his expertise in legislative procedures and the authority for legislative investigations, the rules that govern legislative processes, and these gentlemen will both be available for questions if we may have them as they try to inform us of our legal standing. So I'll wait just a minute, let everybody take a look at the minutes. We actually have two different meetings that we needed to approve the minutes. We lost our quorum last time. I'd want to start with the May 23rd meeting. If anybody just has any questions about that, just take a look and it'll remind you what we've been doing. I was surprised to see in the press that this is our 6th meeting of the committee. It seems like they're moving pretty quickly as we've been in action since back during the legislative session. I expect we will have 2 or 3 more meetings this fall, and we are continuing to get information from members of the public that have concerns and questions and proposed testimony. So we'll have plenty to do as we complete our mission of investigating some of the alleged misconduct and also ways to improve our statutory authority and laws that govern some of the areas that we've heard testimony on. Everything from special grand juries to special prosecutors to funding aspects of district attorneys' offices and accountability for the expenditure of public funds. Those type of things we'll all look at before we come up with final recommendations of the committee. Having reviewed these minutes, is there a motion to approve the minutes from the May 23rd meeting?
Mr. Chairman?
Yes.
I wanted to just make a comment.
Hang on one second.
I was not
Mr.
present.
Leader.
Okay. I was not present physically at the meetings, but I did participate online. There was not a Zoom function, but I listened to it. And so since questions weren't asked, I feel like I wanted to make that be put on the record. But with that being said, I would make a motion to approve the minutes as presented.
Was there one particular thing about the May 23rd meeting you had a question with?
No, sir. No.
Questions not being asked?
No.
Okay.
This time, but you did a good job as always.
Well, I appreciate you participating by online with us. I recognize we have very busy schedules and lots of travel in the off season. So we're trying to announce these in far in advance as we can. A couple of them did kind of sneak up. So Mr. Pro Tem, you are recognized.
Yeah, Mr. Chairman, similarly, I think I got circumstances, but I was trying to get here, maybe got caught in traffic, but I too was listening in as well.
Well, we wrote you down as arrived at 2:57. You were tardy.
I was tardy.
We
I know I
you
got
were
here,
participating.
but I was doing what I could to get here and listening on the way.
That particular meeting on May 23rd, we started at, we were planning to start at 2 in the afternoon, I think, because we knew we had some travel problems. So thank you for your efforts.
Yes, sir.
All right. Any other discussion? Is there a motion? We have a motion to approve and a second by Senator Dolezal. Any further discussion on the minutes of the May 23rd meeting? All right. All in favor of approving the meetings, vote aye.
Aye.
Any opposed? All right. Same thing now on the August 9th meeting, which was our last meeting. If anybody has questions about these proposed minutes.
Motion to approve.
All right. So again, we have a motion to approve. Is there a second?
Second.
Second by Senator Dolezal. Any discussion on these? All right. All in favor, say aye. Any opposed? All right, they are unanimously approved. We are also joined today by Mr. Josh Belafonte, who as legal counsel has been retained by the committee to represent our interests that in certain litigation that it's already really been filed, but it's more to come, I think, in the enforcement of subpoenas before this committee. I will expect that at the conclusion of the public portions of this meeting and the public testimony, we may go into executive session to have him, under our attorney-client privilege, advise us as to the current status of any pending litigation. All right, at this time, then I want to have Mr. Stuart Morelli introduce himself and just give us an update on the sort of the legislative process here, the investigative powers of our branch of government, and the ability to have witnesses to testify under oath, and our issuance of subpoenas. As a member of the Legislative Council's office, you are assigned to this committee, and we appreciate your efforts in helping us behind the scenes be prepared and follow the appropriate procedures up until this date. And you shared with me this memo that was really, it's 13 or 14 pages long, that was prepared some years ago by your office. If you would just kind of give us a general overview of the research and work that you've done and the big scope of things, the legislative investigative powers.
Yes, sir. So, as the chairman said, I believe each of you have a copy of the 2016. I've always called it a manual, whether you call it a manual or a memo. It is the research our office conducted some 8 years ago in outlining the legislative investigative powers, including the abilities to issue subpoenas and compel witnesses to attend. When you're looking through that, you'll notice that a number of citations go back to, of course, Mason's Manual on Legislative Procedures, which I may also be, referencing, in my presentation today. Mason's does a very good job of, outlining the various the powers of legislative bodies, as well as the procedures in them, and cites to, case law in states to support its positions. So as a general matter, it has been found almost universally by the various courts that have looked at the matter, including the United States Supreme Court and Supreme Courts in our sister states, that all legislative bodies have an inherent power to conduct investigations. As the Supreme Court reaffirmed, the United States Supreme Court reaffirmed in 2020, that power is inherent to the legislative process, as in it does not have to arise from a specific grant of statutory or constitutional authority.
This 2020 case would not have been in the 2016.
No, sir. And I'm going to provide some, that information on this case. It is the Trump v. Mazars case out of the United States Supreme Court in 2020. In the Mazars case, the Supreme Court did provide that Congress has no enumerated constitutional power to conduct investigations or issue subpoenas, but we have held that each house has the power to secure needed information in order to legislate. And they cited to a 1927 opinion of theirs, McGrain v. Dougherty. The Mazars case, Mazar court went on to provide the power of inquiry with process to enforce it is essential and appropriate auxiliary to the legislative function. Again, citing back to their 1927 case in McGann. The Mazars case then went on again to state, without information, Congress would be shooting in the dark, unable to legislate wisely and efficiently. As I said, in 2020, the Supreme Court was citing back to its 1927 precedent, upholding Congress's power. State Supreme Courts have held the inherent power of their legislatures to conduct investigations, going, I believe, as far back as 1824, when the Massachusetts Supreme Court, I believe, was the first state Supreme Court to address the matter. As I said, it has been a near universal finding that legislatures have this authority. The only dissenting view that I'm aware of was stated by Justice Thomas in the Mazars case. He did believe that the precedent relied upon by the Supreme Court and the other state Supreme Courts was misguided, but no other justices joined in that opinion. other state Supreme Courts have continued subsequent to the issuance of Mazars to continue to also uphold state legislative investigative powers of their legislature. I will.
Was that an 8-1 decision then, or?
Justice Alito dissented on different grounds. He did not join Justice Thomas's dissent, so it was 7-2.
Okay.
And just for the record, the Georgia Supreme Court has never addressed legislative investigations. It just has not been an issue that has made its way to the Georgia Supreme Court. So it does appear that there is virtually no case law directly on the ability of the General Assembly to carry out or to compel testimony and compel witnesses to appear before it and to produce documents. In addition to the near universal finding that legislative bodies have an inherent power, it has also been the near universal finding of the U.S. Supreme Court and other state Supreme Courts that the power to investigate is not only possessed by the entire legislative body, but also by its constituent chambers, and that those powers can be exercised by one chamber on their own. So bicameralism has never been found to be necessary to carry out an investigation, to compel testimony for a full chamber of a legislative body. And also, the courts have universally, when the issue has come before them, held that a legislative chamber is fully within its right to delegate its legislative investigative powers to a committee, including the power to compel testimony and subpoena documents. However, the case law is also clear that absent such an affirmative delegation, a committee does not on its own have any inherent power to conduct investigations. And the investigatory powers of a committee are limited to those that are specifically granted to it by its parent body. One area in which there is not a universal holding when it comes to legislative investigative powers would come to the ability of a legislative body or a committee of a legislative body to conduct its hearings and to compel testimony once the legislative body has adjourned sine die. There is a conflict between the state courts that have interpreted this matter. Some state courts find that it is perfectly fine for a subcommittee or for a committee to compel testimony after the parent body has adjourned sine die. Some Supreme Courts have found that it would require a joint resolution of both chambers of a legislative body to allow that to happen, finding that once the General Assembly had adjourned sine die, there would need to be some level of bicameralism for the investigative powers to be conducted. And some state Supreme Courts have held that such investigations are completely prohibited, based upon the rationale that since the investigative powers are auxiliary to the legislative power, and since a legislature cannot legislate once it is adjourned sine die, then the auxiliary power itself would disappear. Luckily, here in Georgia, we do have a constitutional provision that addresses the ability of the General Assembly to establish interim committees. Article 3, Section 4, Paragraph 4 of the state constitution provides that each house shall determine its rules and procedures and may provide for its employees. Interim committees may be created by or pursuant to the authority of the General Assembly or of either house. So the people of the state of Georgia have empowered each chamber of the General Assembly to establish interim committees as they so choose.
Let me hold up just to make sure we all understand this then. In the state of Georgia, it is in the Constitution that each body, the House and the Senate, may establish committees that's work may continue after sine die.
Yes, sir.
Okay. And so any of these other states that have varying decisions would be based on their statutory law and their constitutions.
Yes, sir. That is correct.
No Georgia court has ever held that our legislature doesn't have the authority to meet in the off season, as many of us call it, but when we're not in legislative session.
Yes, sir, that is correct.
That's why we have all these study committees that meet every year that are investigating and trying to find solutions to problems and formulate legislation.
Yes, sir.
And as far as you're concerned, does that constitutional provision also apply to investigative authorities as set forth by Senate resolution? Make sure I remember the number here. We have this in the folders as well, 465.
I see no reason why that provision would not apply to a standing or a special committee as well. It would seem to be, it would seem to be limiting the power of it would just, seem inconclusive that why an interim committee could meet, but a standing committee would not, when the Constitution has authorized a type of committee to meet in the interim.
Your legal opinion that we are authorized to meet in the interim by
Yes,
the
sir.
Georgia Constitution. How about under Senate Resolution 465? Does it specify that we are permitted to continue our meetings after sine die?
I don't believe it specifically states that, but it also, unlike the resolutions that would tend to create study committees, does not provide a end date for the committee. A typical resolution committing a study committee talks about how those study committees tend to stand dissolved as of typically December 1st of the year they were created, absent any type of explicit date stating when the committee dissolves. The resolution would appear to indicate that this committee has the authority to continue to operate until the 158th General Assembly is sworn in. This being the 157th General Assembly.
Okay. I apologize for my interruptions, but I didn't want to forget them. So back to your presentation.
So, and this is kind of along the lines of, in addition to the constitutional provision, while there has not been any case law that addresses the ability of the General Assembly to conduct investigations, there have been, on, as far as I can tell, 4 occasions where the General Assembly or a chamber has created a committee to conduct investigations and to study the affairs of the state. And in all 4 of those situations, it does appear that those committees did carry out their powers once the General Assembly adjourned sine die. The most, I would say, the clearest example of this authority comes from 1871 with joint resolutions 7, 9, and 12 of the General Assembly. Both of those, again, were adopted by both the House and the Senate. They established various joint committees to investigate the issues arising of former Governor Rufus Bullock's administration. These resolutions specifically granted to those investigative committees the power to compel witnesses and subpoena documents. Then in 1896, the House of Representatives, and through a resolution, established a committee to investigate each department of the state government. The resolution was adopted on the day that the General Assembly adjourned sine die. So there was no way that that committee could have carried out its functions during the session. Based upon the House journals, it does appear that that committee did conduct extensive investigations in the interim in 1896. In 1897, the committee filed its report with the House, and the committee report and the minority report go on for about 86 pages. They provide a very in-depth, detailed examination of the affairs and operations of the various state departments. This committee apparently went to the offices of each state executive officer, inspected their books, investigated their practices. There is a in-depth discussion of the ability of the affairs of the Department of Agriculture at the time. It appears that the committee questioned the best practices the Department of Agriculture was carrying, not only in bookkeeping, but in contracting with various contractors. I believe it was to provide tags for seed oil. Not being an agricultural guy, I don't completely understand that. They also, there are references in the committee report to how they visited each of the state's hospitals at the time, commenting on even when they went to the school for the blind, that the dormitory for one set of students, the boiler room was lacking adequate insulation around the boilers. So it was a very in-depth review, digging into the details and operations of the various departments of the state executive branch. And again, making comments on their bookkeeping, making statements on how much funds they had. The committee made a number of recommendations, both for potential legislation to address matters that they saw, as well as to recommendations on future appropriations, whether to increase or decrease the set levels that had been given to the various state agencies. I will note that the 1896 resolution by the House does not state that it grants the committee the power to compel witnesses, but as I said, they undertook an extensive investigation. The report makes no indication of whether or not the executive branch objected. So I cannot speak to whether or not they were forced in some manner to get the executive to comply, but the report is silent as to that matter. And then finally, at least in the past 100 years, we're getting up to, in the 1964 special session, the Senate adopted Senate Resolution 30, which established an interim committee to make a comprehensive inquiry into the Stone Mountain Memorial Association. I just discovered this resolution last night and was unable to get my hands on the Senate journals for the 1965 session, so I do not know what the report said. The 1964 resolution creating the interim committee to investigate Stone Mountain Memorial Association also was silent as to whether or not it delegated the power to compel witnesses. I was able to see that a number of bills were proposed and adopted in the 1965 General Assembly, revising various provisions of the law governing the Stone Mountain Association. So I would make the assumption that the committee did make some recommendations that led to that legislation. Enforcement of legislative subpoenas has also been a matter that the courts have been forced to address throughout the history of the United States. Going back to 1821, the United States Supreme Court in the Anderson v. Dunn case did find that each House of Congress did have the inherent power of contempt. In that case was an actually case where a gentleman was detained by the Sergeant of Arms of the House, and he had sued under habeas corpus to get his release. And the Supreme Court did uphold the finding, the Federal House of Representatives finding of contempt, the power to find him in contempt for refusing to come testify before them. In addition to the inherent power of contempt that most courts have found that legislative bodies have, judicial enforcement of subpoenas has kind of been the more modern practice if a state has not adopted a specific statutory procedure for enforcing its subpoenas. There are some states, like New Jersey, for example, has a very detailed provision for the enforcement of legislative subpoenas that ultimately can result in a person being held in criminal contempt if they fail to abide by a subpoena. In Georgia, we do have a couple of statutes on the books that do provide some degree of guidance for judicial enforcement of legislative subpoenas. One that I will not spend a lot of time addressing, nor does the manual, are the provisions in Title 28 regarding the House and Senate ethics committees. Those are really much more designed to carry out ethics investigations into members of the General Assembly themselves. Of course, we can get into that if anyone wants, but they are not, those provisions don't seem particularly pertinent to the present committee. In addition to those provisions, there are the provisions of OCGA 48-15-17 and 45-15-17 and 45-15-19. OCGA 451517 provides the authority to the Attorney General to conduct investigations into the affairs of the state and does now provide procedures by which the Attorney General can compel people to appear before his or her investigations, subpoenaing those witnesses and subpoenaing documents as part of those investigations. In the event that the Attorney General is forced to enforce, if somebody refuses to comply with one of the Attorney General's subpoenas, the code provides that the Attorney General has the ability to go to the Superior Court of the county where the person to whom the subpoena was directed resides to seek judicial enforcement. OCGA 481519 grants both the governor and the General Assembly the exact same authorities that are granted to the Attorney General in 481519. While these statutory provisions do exist both in 4815, both in Title 45 and in Title 18, they in no way override the General Assembly's inherent authority to conduct investigations or its inherent authority to carry out contempt procedures or its inherent authority to attempt to enforce its subpoenas. Article 3, Section 6, Paragraph 3 of the state constitution provides that the General Assembly shall not abridge its powers under this constitution. No law enacted by the General Assembly shall be construed to limit its powers. Therefore, the provisions of Title 45 and Title 28 are not limitations upon the General Assembly's power. They are additions to its inherent power and have probably been enacted to provide some guidance to the judiciary if the General Assembly is ever in need of its assistance in enforcing its subpoenas. Absent some sort of statutory provisions for the courts to refer back to, it would appear, and this has been the case in some of the older case law from other states, is that the courts are then forced to resolve disputes into legislative subpoenas using their equitable powers. So it just, at that point, it gets much more complicated for the courts to determine those matters absent some sort of statutory guidance provided. One area that is not addressed in the manual, but I felt needed some updating, especially in light of the Mazars case, are questions regarding separation of powers. And the Mazars case does lay out that courts, when considering legislative subpoenas, in certain cases in Mazars case, the president, need to show some heightened concerns to recognize the separation of powers. However, one thing that the Mazars case is very clear about is that it is limited to issues regarding congressional subpoenas to the President of the United States. As the Mazars court says, the president is the only person who alone composes a branch of government. It goes on to state, the interest of the man is often connected with his constitutional rights of his place. A balanced approach is necessary, one that takes a considerable impression from the practices of government. Courts must perform a careful analysis to take adequate account of the separation of powers principles at stake, including both the significant legislative interests of Congress and the, quote, unique position, unquote, of the president. So it would appear that the Supreme Court in the Mazars case, when they're setting these heightened standards of separation of powers, is designing that to specifically address the unique arrangement in the federal constitution where the president is the executive branch under, I believe, what is generally called the unitary executive theory. Two state Supreme Courts, as far as I'm aware, well, two state appellate courts have addressed the Mazars case and how it applies to state separation of powers issue. The first court case was the Montana Supreme Court, and I can give you all the citation for that case if you give me a second. Sorry, there we go. McLaughlin v. Montana State Legislature. In that case, the Montana legislature had subpoenaed the court administrator to request all emails that the court administrator had with the various judges of the Montana judicial branch to investigate whether apparently the Montana legislature had been considering some legislation regarding, I think, judicial compensation or some such. The judges circulated a poll amongst themselves, and the legislature was interested in the results of that poll. Ultimately, the Attorney General of Montana, challenged legislative subpoenas, and the Montana Supreme Court did find that separation of powers in that case did require, and citing favorably to the Mazars case, that the legislature had exceeded its authority. Ultimately, the Montana Supreme Court found that Montana, similar to Georgia, has a procedure for judicial punishment, and that the alleged purpose of the subpoena was to investigate whether or not the judges had complied with the Open Records Act, and the Montana Supreme Court determined that that was not a function of the legislature, since there was an established procedure for the punishment of judges. The Montana Supreme Court found that the resolution setting out, or the subpoena issued by, it was, I believe, the Standing Judicial Committee of the state Senate there, did not properly detail a legislative purpose beyond seeking to see if the judges had complied with their Open Records Act. The other state appellate court that has addressed the Mazars case would be the Commonwealth Court of Pennsylvania, which I believe is their intermediate appeals court. The Pennsylvania Commonwealth Court in Costa v. Ward found that Mazars was not applicable to an issue arising when the Assistant Secretary of State of Pennsylvania attempted to quash subpoenas issued by their state Senate. The Costa Court, the Pennsylvania court, did find that the Mazars case was limited in scope to the specific unique role that the president has in the federal system. However, we also have a Georgia case, which is not directly on point, but it does address the issue of separation of powers when it comes to governmental investigations. In 1975, the Supreme Court issued an opinion in Dean v. Bolton. In the Dean case, the lieutenant governor had requested the governor to request the attorney general to conduct an investigation into the travel and expense accounts of a state senator. That investigation was conducted under the previous version of OCGA 48-15-17. It occurring before the OCGA was codified in 1983. I don't have the specific site. The language, though, the statutory language had not significantly changed in that, in that period of time. The senator challenged the investigation on the grounds of the state's separation of powers clause, constitutional separation of powers. The Georgia Supreme Court went on to provide, let it be sufficient here to say that this constitutional provision does not prohibit a person in the executive branch of government or a person in the legislative branch of government from investigating the official conduct of any person performing duties in any branch of government. The General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations. So,
But hold on right there. That sounds directly on point, if you ask me.
It was not directly arising out of a legislative subpoena. It is directly on point to the statutory provisions that the General Assembly has and were cited to in the resolution establishing this committee.
And those are the same statutory provisions recited in our resolution forming this committee?
Yes, sir.
Or their predecessors?
Yes, sir.
Would you give me the citation to that case?
Yes, sir. I'm sorry. I've been a bad attorney and not giving you the cites.
You got a whole bunch of attorneys on here, and you got a couple of non-attorneys that are as smart as.
And I can provide copies of any and all of these cases to any members who wish them. The citation for Dean versus Bolton is 235 Georgia 544, and again, it was a 1975 case.
Yeah, all right, so that's Dean versus Bolton. Yes. 235 Georgia 544.
Yes, sir.
All right, so would you read that holding one more time? Because it sounded like it said that the executive branch, Attorney General in that case, did have the authority to subpoena records concerning improper conduct in office of a state senator,
Yes,
dealing
sir.
with the travel and expense reimbursements.
Yes, sir.
And that same code section that gives the Attorney General that authority is what we're traveling under here, that gives the same powers that the Attorney General has to the state legislature.
Yes, sir.
Am I right?
Yes, sir.
Would you read the holding that you just read us again?
Yes, sir.
Okay, thank you.
Let it be sufficient here to say that this constitutional provision does not prohibit a person in the executive branch of government or a person in the legislative branch of government from investigating the official conduct of any person performing duties in any branch of government. The General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations.
Okay, so what we're doing is constitutional.
Under the Dean holding, it would appear so, yes,
And
sir.
that's a holding that's interpreting the Georgia Constitution.
Yes, sir.
And our separation of powers allows the legislative branch to investigate other branches of government, other individuals and their conduct in office.
That is that is definitely what can be taken from the Dean opinion. Yes, sir.
Pretty much the
well as the
clear
inherent.
wording of it.
Yes, sir.
Okay. And that was the factual scenario in that case, was looking into the conduct in office of a state senator.
Yes, sir.
All right. That's the only Georgia Supreme Court case dealing with this separation of powers, whether the legislative branch can investigate.
Yes, sir.
Okay.
As far as it was the only one that I found.
Still good law now.
Yes, sir.
And there's no constitutional provision that has been changed that would change the circumstances from 1975 until today.
No, sir. I believe the separation of powers provision of the 1945 Constitution was carried over verbatim into the 1976 and 1983 Constitutions. The only potential relevant change is, of course, the addition I talked about interim committees, which was apparently an addition in the 1983
And
Constitution.
that 1983 Constitution is the current version of the Georgia Constitution.
Yes, sir.
Okay. All right. So before you veer.
Well, I have now reached the end of my prepared
Okay.
notes.
We're going to get some more out of you then. Back to the United States Supreme Court. Of course, that applies nationwide, right? Those holdings.
Those holdings apply to the federal government because it is interpreting the provisions of the federal constitution as it applies to the Congress's power. Those opinions are not binding precedent on the states, but have largely been taken as authoritative precedent. But, as I, said when my discussion about the Pennsylvania court did not accept Mazars as binding precedent, whereas even the Montana Supreme Court, when the state Senate asked for a motion on rehearing, the Montana Supreme Court in their petition to deny rehearing did state that they were citing Mazars only as authoritative precedent, but in no way claiming that it was binding precedent upon the state of Montana.
So when we talk about the idea of legislative oversight, legislative investigations on the federal level, there's a line of Supreme Court cases that say this is an implicit or inherent power of the legislative branch, that you have the power in order to do your job of passing laws in the public interest, creating public policy. You occasionally have to investigate. Similar to when our committees meet during session, we routinely have hearings and have presentations by the author of a bill and any other interested citizens giving pros and cons of the bill, right? And that's necessary for the legislature to do this investigation, to do their legislative duties.
Yeah, yes, sir. The general view is that the investigative power has to be inherent to the legislative process because, again, as the Supreme Court recited in the Mazars case, without information, a legislative body cannot properly legislate, as I believe the Supreme Court, U.S. Supreme Court said they'd be legislating in the dark.
Very similar to probably the seminal United States Supreme case creating judicial review, Marbury versus Madison. I have all the lawyers on this panel, they graduated law school, so they know that one. The United States Constitution never says the United States Supreme Court has the power to strike down a law as being unconstitutional. But
Correct.
they stated that power because it was implicit, inherent. Otherwise, you're a ineffective branch of government as the judicial branch if you don't have that inherent power to set the rules, what is and is not constitutional, right?
Yes, sir.
Same type of principle here on legislative investigations, that is an inherent legislative authority, whether the U.S. Constitution says it or not.
Yes, sir. And
But the Supreme Court, it says they got it,
yes, sir.
even though it's not articulating the Constitution.
Yes, sir. In
Any
fact,
reason that should be different at the state level?
no, sir. In fact, some of these, what I've seen in some of these state Supreme Court rulings is they find that that inherent authority can also be justified under a separation of powers because absent, the ability of the legislature to investigate on its own, would be highly dependent on information provided to it by the executive.
So even if Georgia's Constitution did not give an investigative power to the legislature, it would be implicit if in keeping with the United States Supreme Court's interpretation of the separation of powers.
Yes, sir. Yes, sir.
And the provision you read out of the Georgia Constitution, does it essentially give us that constitutional authority?
The state constitution does not give an explicit power to it and to conduct investigations. It does specifically authorize the provision I cited specifically gives the General Assembly and its chambers to establish interim committees to conduct, activity once they've adjourned sine die. Since the General Assembly cannot legislate post sine die, really the only activity those committees could take would be studying or investigating.
And that's what we're doing, studying and investigating here. The Dean versus Bolton case was a Georgia Supreme Court that says the legislature does have investigative powers.
Yes, sir.
Okay. So even if it's not specified verbatim in our Constitution, our courts have followed the United States Supreme Court interpretations that the legislature has an inherent ability, power, authority to investigate.
Not in so many words, but I would say that your statement is correct.
Okay. And this committee, in our resolution that formed us, and I'm going back to Senate Resolution 465, says at line 81, section 4 here, the chairperson shall call all meetings of the committee. Committee may conduct such meetings at such places and at such times as it may deem necessary or convenient to enable it to exercise fully and effectively its powers, perform its duties, and accomplish the objectives and purposes of this resolution. That in no way limits the meetings to just during the legislative session, does it?
I do not read any specific limitation.
It's whenever the chairperson calls the meetings and at any places and times as we deem necessary to do our job, right?
Yes, sir.
Okay.
Up through I would say up through when the next General Assembly is sworn in on the second Monday in January 2025.
So to that point, we're no longer in office. The biennial is over.
Yes, sir.
Might be in office if we're lucky enough to be reelected and have chosen to run, but otherwise it'll be a new General Assembly then.
Yes, sir.
Okay. Is it your legal opinion that we are authorized to conduct investigations and hold meetings and take binding actions up until, I guess that's the second Monday in January of 2025?
That would be when ultimately this committee disappears along with the 157th General Assembly itself.
And let me shift your attention a little bit to the resolution itself then. Because I'm looking at this as sort of three various grants of authority to this committee. Number one is this constitutional authority, whether specified precisely in the Constitution or just the implicit inherent powers that have been validated in the Dean and Bolton case, at least. Additional statutory powers under the statutes you've referenced, those would be not limiting, but in addition to this inherent or implicit power. Right.
Yes, sir.
And then the powers given under this Senate resolution that was passed and became law authorizing this committee.
Yes, sir.
In that, can I direct your attention to that resolution? It's in each person's folder as well. Okay. On page 3, starting at lines 45, I'll just read. Whereas such inherent powers include the authority to create special committees for the purpose of conducting investigations and to endow such committees with all the inherent powers of investigation possessed by the Georgia Senate, including the power to compel the appearance and testimony of witnesses and the production of records and the power to place witnesses under oath or affirmation. Does that language specifically give us the power to subpoena witnesses to testify before this committee
Yes, sir. It would appear to me that it does.
and to produce records for our investigation in the course of our duties?
Yes, sir. That paragraph does appear to be an explicit delegation of the Senate's inherent powers to this committee.
Is this in any way inconsistent with any statutory authority in Georgia or constitutional provisions in Georgia?
It is not contrary to any constitutional provision, and because it is the inherent power of the body arising from the Constitution, I don't believe a statutory provision could conflict with it.
Okay. The resolution goes on in lines 50 to 54 to say, in addition to such inherent powers, Code sections 45-15-17 and 45-15-19 empower the General Assembly to make investigations into the affairs of the state and further authorize compelling the appearance and testimony of witnesses and the production of records, and grants the power to place witnesses under oath or affirmation and to enforce subpoenas issued pursuant hereto. Is this just an additional power to subpoena?
Yes, sir.
Okay, and that's what's contained in those two statutes?
Yes, sir.
Okay. Tell us about those two statutes.
Yes, sir. Again, 45-15-17 is the statute that grants investigative powers to the Attorney General that I talked about earlier, including the ability to subpoena witnesses and to compel the production of documents. It also does provide the procedures for enforcing those subpoenas, whereby if a person refuses to comply with the subpoena issued by the Attorney General is empowered to seek judicial enforcement of those subpoenas by going to the Superior Court of the county of the residency of the subject of the person to whom the subpoena was directed.
And does that statute give the legislative branch the same powers and authorities as the Attorney General?
OCGA 45-15-19 gives the General Assembly the same powers that the Attorney General has in 45-15-17.
So those powers of the Attorney General to subpoena and compel testimony or documents is granted to the General Assembly in 45. You got that?
15-19.
15-19.
Yes.
Okay. And that's recited in our resolution that formed this committee, that we possess those powers.
Yes, sir.
In addition to the power granted through the resolution itself, and in addition to our inherent constitutional powers.
Yes,
sir.
sir.
Okay. Do you have any question that this committee has the power to subpoena testimony or subpoena documents in furtherance of the duties set forth to this committee in the resolution 465?
No, sir.
Okay. Any other senators have questions? I want to recognize the minority party as our rules provide to ask any questions. And Senator Jones, I'll look to you since you've done that. Since this is more of a presentation than sworn testimony, since he's counsel for our committee, I'm going to defer to you. But then if other committee members have specific questions, unless there are objections, we'll do that.
Right.
You
I just-
you have the floor.
I
Let's
just
make
have
sure
one.
you lit up. All right.
And that was the 4 instances that you gave about them, I guess the committee doing an investigation after sign or die. You got to go back into that a little bit more. And it was the last time that happened was in 1964. Is that correct?
Yes, sir. The last time that I'm aware of a committee being created, a committee being created specifically to investigate a specific part of the state government was the 1964 resolution that the Senate did regarding the Stone Mountain Association.
And, and obviously no one has ever, because it's never come up. So this would be a case of first impression, I guess.
Yes, sir.
If it goes to court. Have anyone given any legal opinion about why they may believe that they are not subject to subpoena? Like, what's the counter argument? I'm just curious.
My understand, there, people who have court, like in the Montana case, the court administrator did argue that, the subpoena went beyond a legislative purpose. There are limitations that, a legislative subpoena must, be in furtherance of a legislative purpose. And so there are many instances where people have challenged a subpoena issued by a legislative body alleging that there is no legislative purpose behind this investigation.
And do you think that would apply in this case? Of course, we don't really know, do we?
The resolution, under my understanding of the resolution, is that it is designed for this committee to investigate potential legislation to be introduced regarding potential matters of appropriations regarding district attorneys, the contracting procedures, especially in regards, I think it specifically references hiring special prosecutors. So my understanding of the resolution is it does outline a legislative purpose for the committee.
Yeah, I think so. Thank you. That's all.
And doesn't it specifically direct us to investigate the conduct of District Attorney Willis's alleged conduct?
Yes, sir.
So it wouldn't be out of line to invite or to compel her to appear before this committee then, would it?
Not if this committee believes that is in furtherance of its legislative purposes.
Seems it's almost fair to give her a chance to defend herself and give her side of the story. Agreed or not?
I have no position on that, sir.
That's the lawyer answer. That's good. And that's what we pay y'all the big bucks for, is just give us impartial advice. Thank you. Other committee members with questions? Senator Tillery, I'll recognize you.
Thank you, Mr. Chairman. Thank you, Mr. Morelli. I have one question. I heard you read the Dean opinion that talked about let it be sufficient to say the constitutional provision does not prohibit a person from the executive branch from investigating, or from the legislative branch from investigating. Then I want to go to that next paragraph though, because you've studied this more than we ever will. The sentence that said the General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations. In your research, I understand where you've tied this up, but I want to look at the little hole here and say, have you in your research found any statutes or procedures that the General Assembly, since this decision, have enacted that would limit that power that you discussed that Dean appears to give?
Yes, sir. Actually, following the issuance of Dean, or almost concurrent potentially, the predecessor to OCGA 45-15-17 was amended in 1975. And one of the provisions added at that time, and I'm going to pull that was a subsection D to OCGA 48-15-17, which specifically provides that nothing within that code section shall authorize the Attorney General to investigate members of the General Assembly during session.
During session.
Yes, sir.
So if we carried that same provision over to 48-15-19, then
that statutory provision, of course, could not, but the Constitution does grant each chamber of the General Assembly the ability to, govern and investigate. There is an inherent and constitutional power of each chamber to govern the conduct of its members.
Gotcha. So that whole would not be able to eviscerate the power that it appears that we have through the Constitution and then through the progeny of Dean.
Correct.
Gotcha.
And further backed up by the provisions of the ethics provisions of Title 28, which were subsequently added much more, I think in, the early 2020s, the detailed ethics provisions that give a second independent statutory procedure for the ethics committees to issue subpoenas.
All right, other questions? I would, Mr. Leader.
This will be short. Stuart, thanks for being here today. It's great to see you this summer. OCGA
Thank you, sir.
55, 15, 17, and 19. When were they adopted into law and by which governor was it signed?
I don't know which governor. They were initially enacted into law in, I do have that before me if you will give me a second. It was in the 1950s. I do know that much. I don't, I want to say 57. I don't know who the governor was.
Any stories behind the reason for the laws at the time?
My research did not delve that far. I've saw the statutes are on the books, and in preparing for today's meeting, I went and pulled when they were initially enacted,
Okay.
but I did not do any further research on what may have created them,
Thank you.
caused them.
All right, I would advise all committee members that Mr. Morelli is available to all of us if you want him to follow up with any further cases or explanation or updates. You're all free to contact him directly. He is assigned to this committee as a resource to each committee member. The memorandum, I call it, they call it the manual on investigations and subpoenas was done back in 2016. We each have a copy of that in our folders, and it sounds like he's done some updated research. I just have one more question. We need to move on. That Supreme Court case, is it Mazars that you're saying?
Mazars.
Mazars. Is that one where the president was objecting to subpoenas from some congressional committee?
Yes, sir. A variety, I believe multiple committees of, I think it was the House. That was the case where they attempted to get his bank records. Mazars USA was one of the accounting firms, I believe, that personally worked for President Trump and his businesses. One of multiple, I believe, House committees attempted to obtain documents from them. Trump
So they
President
objected to the.
President Trump objected to his bankers releasing the documents. So
did the Supreme Court force them to produce the documents in
well,
the
the Supreme Court overturned it, both that I believe there were cases both before the DC, the U.S. District Court for the District of Columbia, and some in the Southern District of New York. Both of those trial court levels did go up to the relevant courts of appeal. Both the DC Circuit and I believe the Second Circuit upheld the subpoenas. The cases were merged before the U.S. Supreme Court, and the Supreme Court found that both the various courts of appeals and district courts did not sufficiently consider separation of powers issues relating to the president, remanded the matters back. I believe ultimately the various trial courts and courts of appeals allowed the committees to get some documents, but not as many as they had initially been seeking.
Yeah, and so the limitations on those subpoenas were due to the presidency, not other government agencies.
It was based upon the finding that a legislative subpoena on the president's personal documents so interfered with with the entirety of the federal executive branch, because under the unitary executive theory, the president is the executive branch.
So is this when they were trying to get his tax returns?
There is separate case law on that, that did go up. I believe they did get those. Those are based on
We're
statutory
not asking
grounds.
for Ms. Willis's tax returns. Senator Dolezal, do you have a question?
Yeah, but just really one quick question. Mr. Morelli, would it be accurate to say that this February 26th document it essentially serves as a basis for the authority delegated to this committee in Senate Resolution 465?
I mean, it is intended, the reason I call it a manual is because it was intended by our office to be a guide to members and committees of the General Assembly on how to carry out investigations if they wished.
Is there anything that you've seen in Senate Resolution 465 that's in conflict with either the manual or anything that you have since discovered in your legal research, whether it be in Mason's or previous court precedent?
No, sir.
Thank you.
All right. Thank you for being with us. Don't
sir.
leave us, but go back to your role here behind the scenes, advising us and watching. And if you think of additional information or new cases come to light that you think will be educational to our committee, please present those to us along the way.
Yes, sir.
Okay. Former Secretary Cook, please come forward. So good to see you again. Thank you.
Now get out of your way. Do you want me? I mean,
No,
the chairman has dismissed me, but.
you're not dismissed. You're just taken off the hot seat. If you want to sit up there, you're welcome to, because you guys are both just full of knowledge. That's good for us.
I'm gonna go back to my preferred spot, hiding in the corner.
All righty. We do. We do. You'll raise your right hand. I'm gonna swear you in for the committee. You swear the testimony you'll give before this committee will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
All right. Please state your name, your previous position, and tell us what you're doing now in retirement.
I wish I could get to retirement. I'm almost there. My name is David Cook. I am the former Secretary of the Senate. I am received my law degree from the University of Georgia in 1982 and have been associated with the Senate actually going back to 1977. And the Dean case that you were talking about earlier, I remember very well. It was my first year as the reading clerk for the Georgia Senate when Roscoe Dean was tried on my birthday, January 27, 1977, in front of the Senate for a contempt proceeding. So I was kind of chuckling when that case came up. But I've been associated with the Senate in one way or another for a number of years. I was Secretary of the Senate for the last 11 years and retired at the end of last month.
In your role, you have been a great guide to the Senate and the Committee on Assignments and other senators that have had procedural questions and issues, and you've been a great help to me, providing me just binders full of information, especially on how investigations have been conducted by legislative branch at all levels of government. So I wanted you as sort of a subject matter expert to tell us your thoughts today. Just give us your preliminary reviews and talk to us about the power to investigate of the legislative bodies, the Senate in particular.
Good. Well, thank you. I think the question before the committee obviously is, does the committee have the authority to investigate, to subpoena witnesses, and to compel production of that testimony or of documents? And I am of the opinion that the Senate clearly, and that this committee clearly has that authority. I'm in agreement with counsel who just testified here. I think he did a good job of laying out the law regarding the power to investigate. I want to come at it more from a parliamentary law, parliamentary procedure standpoint, but there's no way to separate those two out. They are both intermingled. So Stuart may have some comments on what I may say, or I'm going to provide some of my understanding of what I think the law says. But I'd like to start to basically give you what I think is an analysis from the viewpoint of parliamentary law and procedure as to why this committee does have the authority to do the investigation, to subpoena witnesses, and to enforce those subpoenas. I would first touch on a few principles of parliamentary law and then move on to our rules of procedure, parliamentary authority that has been adopted by the Senate, and hopefully demonstrate that this committee was one properly created that the subject matter of the investigation is legitimate, that the committee has the power to meet during the interim, which we talked about a little bit, that the committee has the power to subpoena the testimony of government officials and to enforce those subpoenas. So before I begin on the parliamentary path, I think it's fundamental that we tip the hat to the 100 or more years of U.S. Supreme Court case law that says a legislative body has the power to investigate. I don't really know of any court that has said a legislative body does not have the power to investigate. There are some differences when you get down into other issues as, do you have the power to subpoena? Do you have the power to compel that? And I think the contempt power of the Senate, for example, provides some limitations, but there are other avenues to enforce subpoenas as well. So I think the analysis Stuart gave regarding the inherent powers of the Senate is very important. It's what most everything that we're talking about today is based on. Mason's manual, which you referred to a little bit, is recognized as the modern day parliamentary procedure manual for state legislators and legislatures, and is for the Georgia Senate. It's actually interesting. There have been 3 iterations of this manual. The very first one was by Thomas Jefferson when the country was instituted, called Jefferson's Manual. And out of that arose Cushing's Manual, which was used in the 1850s. And in the early 1900s, the state of California, Paul Mason, developed a very robust manual of legislative procedure, and it evolved into what we have today as Mason's Manual of Legislative Procedure. It's the authoritative manual on parliamentary procedure for state legislatures.
Is this the one that the National Conference of State Legislatures has adopted?
That's correct.
Yeah.
California granted NCSL, National Conference of State Legislatures, the actual rights to this in the 1980s. And since then, NCSL, they have a committee of parliamentarians that sit on this, and they update it every decade. So the most recent edition is the one that was updated in 2020.
Tell the committee and the public that's listening to you what NCSL stands for, what that organization is.
NCSL stands for the National Conference of State Legislatures, and it is a national association that is comprised of, to my knowledge, every state legislative body in the United States. And it draws on the expertise of members of the legislature and staff to help the state legislatures perform their functions as legislative bodies.
Well, it just so happens that Senator Kennedy and myself were at their national convention this summer.
Mm-hmm.
And there was a session on, I believe it was titled, Everything You Want to Know About Legislative Subpoena Power. 3 different states had presenters, and all unanimously said their states had upheld the power of the legislature to do investigations and use subpoenas. It's funny that that issue happened to be, addressed this year, but it was certainly reaffirming to us that all the states claim this power and exercise, and it's been upheld.
Right.
Back to Mason's.
Yeah. And to my knowledge, there's been the power to investigate is derived from the grant of legislative authority that has been given to the General Assembly by the Georgia Constitution. And everything kind of derives from that legislative power. The interesting thing about Masons, the good thing about it is that when you look at our rules, Senate Rule 10-1.5 provides that when any question that's not provided in our rules, which arises and not provided in these rules, the same shall be controlled by the most current edition of Mason's Manual. So the Georgia Senate has adopted by its own rules everything that's in Mason's manual. Obviously, there will be a few things that are a little inconsistent and where we are more specific on it. For example, there's some question about whether you can meet during the interim, but we have a Georgia constitutional provision that allows us to do that, which would override Mason's manual there. So we've adopted Mason's, and we'll be citing that throughout. Both, I think Stuart cited it, and I'll certainly be citing it. Before we get into the substance of the rules, I think it's important to touch on how rules of procedure are applied, and Mason's does a really good job on it right at the beginning of Mason's. In section 4, it puts it pretty succinctly. Mason says that the rules of parliamentary procedure are derived from several sources and take precedence in the order listed below. Those principal sources are, number one, any constitutional provisions. So if you're looking as to how the legislative body should act, constitutional provisions and judicial interpretations are paramount. The next authority are the rules of the Senate that we have adopted. The third authority is, what is our custom? What precedents have we had? How do we normally operate? And we have several ways that we operate that involve precedent and custom. Following that, in the level of authority, are statutory provisions. So in terms of procedure, our Senate rules can trump statutory provisions regarding procedure. Then the adopted parliamentary law, which is Mason's, and then fundamental parliamentary law, which really is pretty succinctly due process requirements that are required for any legislative body, and lawyers are familiar with it, with due process in court, notice and opportunity to be heard, those kind of things. So Mason's is an important part of the Georgia Senate's parliamentary rules. I'd like to take just a minute to talk about committees, because that's what we're talking about here. There are really three types of committees. One are standing committees. They're provided for by our rule, section in Rule 2-1.3. And the purpose of standing committees is to look at issues that we know are going to be continuing. You have public safety, you have judiciary, you have government operations. We know that there are going to be all kinds of issues that occur during the session every year, year after year, that require the establishment of a standing committee to look at those issues. This committee is not a standing committee. The second type of issue, or committee rather, is conference committees, and those committees are created for the specific purpose of resolving differences between the houses. And you all are familiar with those on the last several days of the legislative session, where we have conference committees meet and work out disagreements between the House and Senate. And the third type of committee are called special committees. And special committees are created for the consideration of a specific task or duty, or to look at a specific issue, or to perform a specific function. These committees can also be named ad hoc, investigating, select, or study committees. We refer to them a lot as study committees here. And special committees are created by a resolution, either by resolution, they can be created by a motion from the body. In this particular case, SR 465, the resolution that created this committee, was established by a vote of the Senate. Senate Rule 5-5.1 requires 29 votes to establish this committee and pass that resolution, and that occurred in the 2023 session. So the committee was appropriately established as a special committee of the Georgia Senate. So what are the committee powers? So the creation of a committee is authorized, as I said, by a resolution. And I think it's clear, I've kind of refer to Mason's here a little bit and quote them. The Mason's provides that the legislature may proceed to make investigations with its authority by authorizing committee of one or both houses. So there's been some question of whether the Senate can act without the House, but Masons clearly says that either house can establish a committee for purposes of investigations. Masons also says that the right to investigate any lawful matter is a right separate and distinct in each house and may be exercised through a committee. That's Mason's 795-11. So the creation of the committee, I think, was done in accordance with statute, in accordance with rules, but it was also done in accordance with our precedents. And Stuart touched on one of those going back to 1871. I think I'm not familiar with that one, but I am quite familiar with the 1964 Senate resolution that created the Senate Committee to investigate the Stone Mountain Memorial Association's Senate Resolution 30. It's actually created during the special session of the Georgia General Assembly in that year and issued a report back, I believe, in the next year. So the committee was, I think, properly established under our rules and under precedents. I think it's also important to note that committees have to be viewed as agencies of the creating body, that this committee is an agent of the Senate. And any committee can exercise only those powers that are delegated to it by the Senate. The corollary of that is that any powers that the Senate does delegate to the committee may be exercised as fully by the committee as it could by the Senate. There's U.S. Supreme Court case law on that, and certainly Masons provides the same thing, Masons 795-5. So the powers granted this committee are broad, and you touched on them earlier, and I think it's important to refer to the resolution. The resolution specifically gives this committee the power to investigate, and specifically in the resolution to investigate the office of the Fulton County District Attorney and the conduct of the Fulton County District Attorney. Mason's Chapter 74, is several pages long, goes on at length about the legitimate powers to investigate of a legislative body. And it's clear from our rules and precedent and case law that the subject area of this resolution is within the scope of the Senate's authority to do that investigation. For example, Masons provides that, quote, an investigation into the management of the various institutions of the state and the branches of the state government is at all times a legitimate function for the state legislature. The U.S. Supreme Court case that Stuart referred to, McGrain versus Dougherty, holds that an investigation into alleged malfeasance is, quote, plainly the subject on which legislation could be had and would be materially aided by the information which the investigation was calculated to elicit, end quote. The U.S. Supreme Court in Watkins versus U.S. said that Congress's power to investigate is at its peak when the subject is the alleged waste, fraud, abuse, or maladministration within a government department. That's Watkins versus the U.S. 1957 case. So the subject matter, I think, of this investigation and the authority of the committee to do it, I think is appropriate. Second, the Senate specifically delegated to this committee the power to issue and to enforce subpoenas. The resolution states, quote, for the purpose of conducting an investigation as provided herein, the committee shall have the power to administer oaths, to call any party to testify under oath at such investigations, to require the attendance of witnesses, production of documents, books, records, and papers, and to take the deposition of witnesses. The resolution goes on further and says, for such purposes, the committee is authorized to issue subpoenas for any witness or to compel the production of books, papers, and records, and is further authorized to undertake such actions as may be necessary to enforce such subpoenas in case of refusal to obey. So I don't think there's any question at all that there's been a full grant of the Senate's inherent power to this committee to investigate and to do whatever it deems necessary and proper to compel the production of testimony and documents. Further, SR 465 specifically grants the committee the authority to meet at such places and times as it may be necessary or convenient to fully exercise and effectively use its powers to perform its duties and accomplish the objectives of the purposes of this resolution. It's line 82 of the resolution. I think this language, as we touched on earlier, is broad enough to include the authority to meet during the interim, which is specifically authorized by the Georgia Constitution. Finally, SR 465 specifically authorizes the committee the power to enforce its subpoenas. The resolution states that the committee is further authorized to undertake such actions as may be necessary to enforce such subpoenas in cases of refusal to obey. The lines 77 and 78 of the resolution. So I think this is an interesting area that people don't, the next area, which is how do we enforce subpoenas, is where people get sidetracked just a little bit. And there's a little bit of a nuance there. I think there are three areas or three methods by which the Senate, and by virtue of its delegation, this committee can enforce its subpoena powers. And the first is by contempt. And that is set out in the Georgia Constitution. And there are some Article 3, Section 4, Paragraph 8. I think there's some limitation in that constitutional provision when you're trying to enforce a subpoena by virtue of the contempt power that's set out. There are different ways to enforce subpoenas, but the contempt power is one. And I think the contempt power can only be used during a legislative session. And it gets into the nature of how does a legislative body use its inherent contempt power. They get the sergeant at arms and they issue an arrest warrant, and the sergeant at arms, which has been in some of the cases and some of the very first uses of the contempt power of a legislative body, they go and arrest. I think the first one was maybe the Secretary of Agriculture, and they arrested him and brought him before the bar of the Senate, tried him and held him in contempt and imprisoned him. But that power to enforce the testimony through contempt is for punishment. And that power of punishment only lasts as long as the session, as we are in session. So once we adjourn sine die, we lose the power to punish for contempt. But there are two other ways to enforce subpoena powers. The second method is through a judicial enforcement of subpoena powers. And I think there's no question, Stuart can talk more about this better than I can, but if the Georgia Senate has the inherent power to do investigations and the inherent power to get witnesses and testimony and information in order to fully inform its legislative process, and that process is stymied or objected to or thwarted in any way, I think the Senate, and by virtue of delegation of its power, this committee can walk over to the Superior Court of Fulton County, seek an injunction in equity. Stuart touched on it, try to seek a declaratory judgment action and an injunction in order to enforce what is its inherent investigatory and subpoena powers. That's called judicial enforcement. So I would say that is the second manner of enforcing a subpoena. And the third manner is by statute. And Stuart laid out what we have is in the statute 45, 15, 17, and 19. I guess the only comment I would have there's this statute, there's a statute that authorizes the Ethics Committee to enforce subpoenas, et cetera. But the inherent power of the Senate and its ability to delegate that power to a committee is constitutional. I don't think anybody would disagree with that. And clearly statutes cannot overturn what is a constitutional power. So I think anytime you're reading a statute where it says the General Assembly, et cetera, that has to be interpreted as supplemental to what are inherent constitutional authorities of the Senate and of this committee. So those statutes, I think, should be viewed as supplementing what the Senate's powers are, not as restrictive of it. So those are my prepared comments today. I'm happy to try to answer any questions that you might have on this, and happy to hear from counsel on anything that I might have said from a legal perspective that he might disagree with.
Mr. Secretary, you were the secretary at the time we issued these subpoenas for Fonnie
Yes.
Willis. In your opinion, are they in compliance with Senate Resolution 465 within the scope permitted under that resolution?
Yes.
Anybody else have any questions for Mr. Cook? All right, thank you for being with, wait, I do.
Oh, yep.
Senator Estevez, you're recognized.
Thank you, Mr. Chairman.
Sure.
And thank you, Mr. Cook, for laying this framework out. So my question is, are you aware of this power and even the enforcement procedures that you've laid out ever coming up before, used by this Senate body before?
And from a legal standpoint, I'm not aware of any, and Stuart, I think, can get more into that than I am. I'm not aware of, I think they're in the Dean case. There were several aspects of that, including a trial for a criminal trial. And there was a contempt proceeding in the Georgia Senate on that. And I think there were subpoenas issued pursuant to that, but I'm not sure. That would have been the only case. And then Stuart mentioned one, I think, that subpoenas were issued back in the 1800s, but those would be the only cases that I'm aware of.
So 150 years ago, and then in proceedings against one of our own members.
Mhm.
Okay. Thank you.
Right, thank you very much. Appreciate you being with us this morning and all your service to the Senate for many, many years. The last person on our agenda, of course, is the first person, Honorable Fonnie Willis. She has not appeared yet. I would ask the doorman, please check the hall to see if she has appeared before we adjourn.
Mr. Chairman.
Yeah. All right, thank you. Then let's please note for the record that Ms. Willis has failed to appear in compliance with the subpoena and has failed to produce the documents requested by our subpoena for the production of documents. At this time, I want to let the committee know that we have hired Mr. Josh Belafonte to assist us in our legal enforcement efforts on the subpoena. And I would like for us to have an opportunity to be briefed by him. We have privileged communications with him under the attorney-client privilege. Our rules do permit, I think it's Rule 5 of our committee rules, that we can go into an executive session or a session that is closed to the public. So that requires a majority vote of the committee. If anybody is interested in having a private conversation with our counsel to let us know where the litigation stands, now would be the appropriate time to move for that. I recognize Senator Kennedy.
Thank you, Mr. Chairman, for that. And I would move that we do pursuant to Senate Rule 1-5.1, as you just stated, have this committee move to go into executive session for the purposes of hearing from appointed counsel to advise us.
Is there a second? All right, we have a second. Any discussion by committee members on the appropriateness of that or the desirability to have a private briefing? All right, all in favor of the motion, say aye.
Aye.
Any opposed?
Aye.
One opposed. All right, at that time, then we will conclude the public portion of this meeting and we will stand adjourned as a public meeting. We will continue in a executive session to be briefed by our counsel on the current status of litigation concerning the enforcement of the subpoena. Thank you. We're adjourned.